All rise. Judge Vanderbeek Court is now in session. Judge, this is case number JVB 1034, Thornton case.
Thank you.
You're welcome.
You all may be seated. Mr. Thornton,
Yes, ma'am.
you're back. How are you doing?
Oh, not as well as I'd like to.
Okay, all right. You brought this case before the court. What's going on?
Well, Your Honor, there's been some significant changes in my situation. And as you can see, Ms. Hernandez is not here today. And I have custody of the boy, and I have been, making our arrangement payments to her.
Okay.
But since the boy has come to stay with me, he's gotten himself into a lot of trouble.
Okay. What kind of trouble?
Well, he's been burglarizing some residents, and he was in an accident due to a police chase.
This is AJ, right?
Yes.
Okay.
Justice has finally been served. The judge dismantled every weak argument, issued a fair child support ruling, and, most importantly, ensured Miss Talley gets to spend time with her son. This case highlights exactly why the courts keep child support and parental access separate, because when it comes down to it, it's not about personal grudges, it's about the child's well-being. No parent should be denied access because of financial disputes. This ruling was a win for fairness and what's truly best for the child. What do you think? Was the judge right? Let us know in the comments. And don't forget to like, subscribe, and turn on notifications for more courtroom breakdowns.
And Ms. Hernandez refuses to acknowledge her responsibility to help me in covering some of these costs. I mean, the medical costs are quite extreme. My insurance is refusing to pay because it was a criminal act. In fact, they're probably going to drop me.
Okay.
And
If I remember correctly, you guys agreed to no child support during mediation.
yes, ma'am, we did.
Okay. And since that time, nothing has really changed with the living arrangement. AJ still lives with you,
Yes, ma'am.
and you still have not been paying child support. You've been making the back child support payments.
Yes, ma'am.
Okay. Other than AJ getting in trouble, what else has happened? Like, what has changed?
Well, she has moved out of state, quit her job, so her insurance no longer covers him.
Mr. Thornton presents his case thoroughly, explaining that Miss Hernandez has moved out of state, quit her job, and her insurance no longer covers AJ. As a result, he's been carrying the financial burden alone, covering medical expenses, court, fines, and damages from the accident. The judge points out that during mediation, both parties agreed to no child support, and asks whether there's been a material and substantial change in circumstances. Mr. Thornton struggles to provide solid evidence of such a change, especially since AJ has always lived with him. His frustration becomes evident as he realizes the legal barriers ahead. This moment captures the emotional and financial weight of the situation, as his desire for support collides with the judge's firm stance.
Aspect, and the court costs, fines, and due to that accident, there was a lot of damage in which he's liable for, or I am, and it's almost impossible.
Okay.
For me to,
But AJ was double insured by both of you, right?
yes.
Okay. Here's the issue. In order to modify any type of child support situation, whether you receive child support or you don't receive child support, there has to be what's called a material and substantial change. That means that AJ's living arrangements would have had to have changed. Something about his educational expenses have changed. Something about mom's income would have had to have changed. But in you guys' case, you agreed in mediation to no child support. So to go from no child support to receiving child support, you would have to fall in one of those categories for a material and substantial change. And based on what you said, you really don't fall into one of those.
That's very disappointing.
The judge takes center stage, firmly explaining that modifying child support requires a material and substantial change. such as a shift in living arrangements, educational needs, or income. She emphasizes that none of these conditions have changed since the original mediation agreement. Mr. Thornton voices his frustration, feeling that Ms. Hernandez is evading responsibility. The judge, however, reminds him that the agreement was mutual and legally binding, and without significant changes, the court cannot alter it. Her no-nonsense delivery leaves no room for misunderstanding, and Mr. Thornton is left visibly disappointed. This scene marks the emotional peak of the case, as the judge's unwavering legal logic collides with Mr. Thornton's heartfelt plea, creating a moment of raw tension and powerful courtroom drama.
Free of any obligation? I mean,
Well, I wouldn't say she's necessarily free, but remember, you all did come to an agreement in mediation to no child support. So in order to start receiving child support, you would have to show that something has changed. So let's say, for instance, at the time of mediation, AJ still resided with her. Now he lives with you, then we can entertain child support at that point. But nothing has really changed since you guys have gone to mediation. Therefore, you wouldn't be entitled to receive any child support, unfortunately.
I understand. I mean, is there nothing I can do? Absolutely.
As far as I'm concerned, no, there's nothing you can do. Yeah.
All right. Thank you.
Okay,
Your
is there
Honor.
anything further?
No, ma'am. Not at this time.
Okay.
That's about it.
Okay, well, if there's nothing further, you're dismissed.
Thank you.
You're welcome.
The judge reiterates her ruling. Mr. Thornton cannot receive child support under the current circumstances. She firmly states that the original mediation agreement still stands, and with no qualifying changes, dismisses the case. Mr. Thornton thanks the judge, but his frustration is clear as he leaves the courtroom, burdened with the knowledge that the financial strain remains solely on him. The judge's closing remarks underscore the importance of legal agreements and the necessity of substantial changes to warrant any modifications. This moment brings resolution to the case and leaves a clear takeaway for viewers. Legal agreements carry weight, and altering them isn't easy. Now, let's break it down from a legal perspective. This case highlights the critical importance of understanding child support agreements and the legal standards for modifying them. According to Texas law, there must be a material and substantial change, such as a shift in income, custody, or the child's needs, to justify a change in support. In Mr. Thornton's situation, no such change occurred, so the original mediation terms remained in effect. The video wraps with a call to action, encouraging viewers to share their own experiences, subscribe, and stay tuned for more legal insights. This case is a strong reminder of the complexities within family law.